Any information that you hear during this presentation is not intended to be legal advice. It's limited and for educational purposes only, to give you broad information. So if you have any questions about the law or anything specific to your situation, please contact an attorney licensed in your state. All right, so when we talk about planning for individuals with chronic conditions, we are really talking about elder law. And this is a term that I've found that many people aren't familiar with, and those who are believe that it is just strictly for the elderly. But when we talk about elder law, we are talking about planning for individuals with disabilities and people with issues that are often associated with aging, but not necessarily an elderly person. So this could include basic estate planning, such as an attorney providing advice on how your assets should be managed, how it should be handled after your death, establishing powers of attorneys, healthcare documents to give your loved ones authority to manage your affairs, setting up trusts, or using other estate planning tools to help avoid probate. This can include probate matters, which includes estates, conservatorships, and guardianship proceedings, which we'll touch on a little bit later. Special needs planning, again, helping a person with special needs manage their assets, specifically to ensure that any benefits that they may be entitled to, such as SSI or Medicaid, wouldn't be in jeopardy. Veterans benefits. Wartime veterans or their surviving spouses may be eligible to receive monthly excuse me, tax-free cash benefits to help cover medical expenses. So that's also part of the elder law umbrella. Medicaid planning, protecting assets to help individuals qualify for long-term care or Medicaid services for long-term care. And of course, other real estate, insurance, Social Security, healthcare, neglect, elder abuse, a bunch of other issues, but primarily planning for the purpose of having long-term care options. And does someone have to be elderly, as I mentioned? No, they do not. It's merely about bringing things bringing the future into the present so that something can actually be done about it now. So essentially, elder law is about helping people, regardless of age, bring the unexpected into the present so they can prepare for it now. And what exactly do I mean by that? We'll jump and look at an example. Let's meet Harriet and Robert. So Harriet and Robert are ages, let's say 75 and 77 respectively. Harriet will be having a hip replacement surgery soon, and a friend suggests that she sees an attorney to make sure that she has the appropriate documents in place just in case she has any complications during recovery, or if Robert should become ill. So what exactly does proactive planning look like for Harriet and Robert? Well, after visiting with an elder law attorney, Harriet and Robert could have comprehensive powers of attorneys, both healthcare and financial, as well as advanced directives to help their loved ones make decisions on their behalf and also make them aware of what their wishes would be. They would also put a plan in place to protect their home, their hard-earned savings in the event that either one of them need long-term care in the future. And this could include a trust, a will, a number of things, just being proactive to ensure that they do not lose their home or their savings to the rising costs of long-term care. One of the documents that I mentioned was a power of attorney, and there are different types. So the first one that we'll talk about is a durable power of attorney. The purpose of this document is to allow an agent to step into your shoes and make decisions for you if you're not able to do that. You determine what decisions could be made on your behalf and how much power you give to this person. And it's important to know that even if it's something you don't necessarily need right now, or you're in the early stages of your illness and you're still able to direct others to manage your affairs, it is something that will be helpful if you need a guardian in the future, or if your health fails suddenly and you're not in a position to actually direct someone on how to manage your financial affairs. But for individuals who are living with chronic illnesses, it's very important that the POAs are very well laid out to address any and all potential issues that could arise. So if we talk about a regular POA, or the POA that most people have seen, it gives someone the authority to access bank accounts, pay bills, sell a home, do basic transactions. But POAs can actually include what I like to call superpowers to address long-term care needs. For example, there are specific things that Medicaid may require if someone has to apply for Medicaid. Without the proper language, a person who doesn't have the capacity wouldn't be in a position to actually give them that information, and a person who's serving as an agent wouldn't be able to relay this information. Transferring assets, changing beneficiary designations, even changing someone's estate plan after the fact so that asset protection can happen. Those are all provisions that could be included in a durable power of attorney with superpowers to ensure that the agent has maximum flexibility and can do anything that they need to do to make sure their loved one has the right long-term care support. The next set of documents are advanced directives. Now, there are a few that could fall under this category. The most common are your healthcare POAs and your living will. So the difference between the two essentially is that your healthcare POA allows someone to make medical decisions for you. It names a person that you trust and lays out what type of authority you want to give them. Do you want to give them access to your medical records right now? Do you only want them to have access if something actually happens to you and a doctor determines that you're incapacitated? Do you want to give them authorization to actually have access to your medical records? All of those things are things that could be laid out in a healthcare power of attorney. A living will, on the other hand, strictly addresses what a person wants to happen if they need life-sustaining treatment. Essentially, if they are at a point where physicians believe they're at a point of no return and there's no possibility that they could recover, and they find themselves on life support or subject to force feedings or any other life-sustaining treatment that could be provided, they could opt out of that using a living will, stating that they just want to have a natural death, and their loved ones wouldn't be forced with making that decision at the last minute. DNRs are very common and documents that a person could honestly get through their doctor. It's not something that most younger people need, or even older people who aren't necessarily frail. But if we have a person who could suffer more harm from getting life-sustaining treatment, getting CPR, or anything along those lines, a DNR would certainly be appropriate. Now, when we're talking about advanced directives, POAs, and chronic conditions, there is a time when it's too late. Oftentimes, people choose to start planning for this or think about this when it's a little bit too late, when they already need the service. And there are a few things that we look at to determine whether or not someone is even in a position to execute one of these documents. So when is it too late? It's not necessarily too late as soon as a person is diagnosed with an illness, but it is too late if they are so far advanced that they have no idea what's going on. In order to execute POAs and advanced directives, a person has to have enough capacity to not only understand what they're signing, but understand the type of power that they're giving away to someone, and also understand that in so doing, they're not taking away their own rights, but they're giving someone the authority to act and do any and all things that they could potentially do. So if they're not in a position to understand the weight of that decision, it is more than likely too late. In some cases, when we're talking about people with chronic conditions, they may understand what's going on for a short period of time. They may feel better later in the evenings versus early in the morning. So even if the capacity is not something that they have all the time, if they have capacity at the time that they're making this decision, then that is sufficient. So having a chronic condition alone doesn't mean that someone cannot update their plan or their powers of attorneys, but they do need to be aware enough to understand what's going on when it's happening. The next document is a last will and testament. This is one that most people are very familiar with. Pretty straightforward, decides who gets your assets and chooses a person to administer the estate. Essentially, a person who's going to be in control, making sure the final expenses are paid, and making sure that all things are distributed the way the person intended. This is, of course, something that all people should have, but it isn't necessarily something that helps with chronic conditions or long-term care planning. So we will talk about some other options for that. As it relates to your last will and testament, when exactly is it too late? Similar to the powers of attorneys, there is a time when a person can no longer create a last will. It doesn't mean, again, that this person has to be completely coherent all the time. But in order to create a will, they have to understand who their family members are, who are the natural objects of their bounty, who their children are, who their family members are. They also have to understand what type of property they have. It doesn't matter if they're able to say, I have 20,000 here or 50,000 there, and I have a 401k with this bank or that bank, but that they understand generally what they have and what can be done. And also, they're able to understand that whatever decision they make through their will, or whatever distribution rather they decide to make through their will, is final. It's going to be what happens after their death. If they're able to understand those things, they understand who their family members are, what they have, and what the weight of their decision will ultimately mean, then they have the capacity to execute a last will and testament. If they're not at that point, then it is without a doubt too late. Another vehicle that could be used for planning are trusts. So lots of people think about getting trust, but it's not necessarily appropriate for every single person. So there are a few things that a trust could accomplish. Deciding who gets your assets is one of them. Getting a little bit more specific and deciding how and when those assets are distributed is something that can be accomplished through a trust instead of a will. Planning for long-term care is also something that can be accomplished through a trust. And also planning for a loved one with special needs could be accomplished the same way. Now, as with the other documents, there is a time when it becomes too late. So when exactly is it too late for someone to execute a trust? Well, they have to have some of the same criteria as a will, understanding who their family members are, having a general idea of what their assets are, understanding the weight of their condition, but additionally, they need to have contractual capacity. So if we're looking at someone and you wouldn't ask them to sign a contract because you don't think they have enough capacity to understand what a contract is, then it is more than likely too late for them to get a trust. So all of these things really require some level of proactive planning in order for them to be successful. So there are two different types of trust that I want to touch on. No matter what the trust is called, it's going to fall under one of two categories. it will either be a revocable trust or an irrevocable trust. And the way I like to explain it to people is that on the left, as you see in the picture, there's a treasure chest, and the person has the key in their hand. So with a revocable trust, you can add assets to your treasure chest. You could take them out. The key remains in your hand, meaning you have ultimate control. And you can make changes as often as you need to, stop the trust if you need to. And for this reason, everything in the trust is considered completely available to you. So if we're talking about potentially qualifying for benefits for long-term care services, this revocable trust would not be the proper vehicle for long-term care planning. Irrevocable trust is similar to what's on the right. You would transfer assets into a treasure chest, for lack of a better word, but you no longer have the key. The key is actually given to another person or people, and that person has control of the assets, meaning they are the lifetime beneficiaries. They are the ones who could take things out of the trust, and you have essentially relinquished total control of the assets you've transferred into this irrevocable trust. And for this purpose, it makes those assets not countable for Medicaid purposes, but only after a specific period of time. So what if it is too late? What if we've bypassed all of these options and we no longer have capacity to execute a document, a power of attorney, a trust, or anything else that we may need to make our loved ones' lives easier in providing care for us? Then the only option that's left is guardianship. So when an individual doesn't have a plan, doesn't have a power of attorney, a healthcare document, or anything that will tell people exactly who they want to manage their affairs, then guardianship and conservatorship is the only avenue that their loved ones would have to actually be able to step in and do the things that need to be done. Guardianship and conservatorship, those terms are often used interchangeably, but they actually do have different meanings. So a guardian of a person manages their health-related decisions, where they live, things of that nature. But a conservator would manage the person's assets, any money that they have coming in, if they have a trust, or if they have lump sums in the bank or real property anywhere, they would require a conservator. This could be the same person, but in some cases it may not be. There may be one person who's better at handling finances and another who's better at just handling healthcare decisions. And sometimes families do choose to go that route. In South Carolina, it is, I want to say that the courts are very respectful to alleged incapacitated individuals, in that the courts want to make sure that a person is not placed under a guardianship or conservatorship if there is there's a least restrictive alternative. So if that person has any level of capacity, like I mentioned before, where they can execute a power of attorney, or they can direct other people to manage their affairs, then that's what would be preferred. Likewise, if a person does have a power of attorney, but they've reached a point where they still require a guardian, their choices would be honored by the court, because that would tell them that this is the person they trust to manage their affairs and to ultimately make sure their needs are being met. All right. So when we've talked a little bit about care, and when I talk to a lot of people, they don't necessarily think about their long-term care needs right away. They think about the things that they're facing. They think about the burdens on their family members. They think about the assistance that they may need to come into their home and clean or cook or whatever the case may be, but they don't actually think about what it's going to look like when they get to a point where even if they want to, they may not be able to stay at home. Or if they are able to stay at home, they would require substantial assistance, 24-hour care. That's just not something that's on most people's radar. But studies show that 1 in 2 people will need some type of long-term care. And that is steadily rising. And if we're talking about people over the age of 70 in particular, more than 70% of that age group will need some type of care. So of course, planning for it is absolutely necessary. We plan for a number of things: vacations, meals, a number of things, but planning is just something that doesn't generally happen. I have some statistics. Okay. I have some stats here, some statistics here that I'm not going to bore you with, but essentially what this is showing you is that with the baby boomers population needing long-term care services, it automatically means that the cost of care is going to go higher. Anytime we need more of something than is available, the cost increases. So in addition to having the baby boomer population to care for, we also have Alzheimer's that's at an all-time high, and Parkinson's and other diseases that cause folks to need long-term care sooner than they would think necessary. Again, more of the same stats that I was just sharing with you. But this is what's important and what people really need to focus on when they think about planning. Because planning is not just about having a certain set of documents in place, but being strategic enough to make sure that we can cover this picture. So when we're talking about people with chronic conditions, depending on the level of care that they need, the cost could be really, really high. So if we're talking about someone who needs not very much care at the assisted living facility, they're still able to do a little bit on their own, we're still talking about a few $1,000s a month. But when we get to a point where we need nursing home services, we're talking about significantly more. So a person who has saved, let's say, a few $100,000, had a modest career or a modest salary, and has some things saved for their loved ones or for their future care, wouldn't really be able to sustain this type of cost long term. Studies also show that on average, people need at least 3 years of long-term care once they get there. So unless you are independently wealthy or have done some really, really good, significant planning, this is not something that most people can actually afford and still be able to leave something for their loved ones or care for their dependents if they have any. Again, just more of a breakdown on the cost in South Carolina, but these numbers fluctuate. It really depends on where you are. So folks who are closer to the beach are going to pay much higher than people who are in Rock Hill. So the options again are to pay out of pocket, to purchase some type of long-term care insurance, which isn't really an option for most people by the time they think about it, to implement some type of legal plan to protect home and savings, or to have a combination of all of the above. Ultimately, what we want to avoid through this type of planning is running out of money, leaving the home unprotected, and risking the health of family members and spousal caregivers. Unfortunately, a lot of times the caregivers are stretched so thin that they may be the ones to need care first. So this type of planning is really important to make sure that a person with a chronic disease doesn't end up in a position where they do not have a caregiver, or they've inherited lots of resources that would make them ineligible for any type of assistance they could receive from Medicaid or any other government program. And I'm sure this will be of no surprise to most, but the people who bear the most risk are typically women. The majority of caregivers are women, and spouses who are caregivers for other spouses with Alzheimer's, dementia, and other chronic diseases are deemed to be at greater risk for emergency room visits and all types of issues because of their deteriorating health. So when we're thinking about planning, even when we're just thinking about the person who is ill, we really need to think about it from the perspective of that person being the spouse who's left, or the family member who's left, and making sure that we have enough provisions to care for that person and also not impact their eligibility for anything they could receive. So ultimately, the answer is proactive planning that includes some type of long-term care planning, not just getting random documents for the sake of having them, but considering long-term care options as we plan. Doing some type of asset protection if it applies, and it doesn't apply to everyone, to make sure that those services are going to be available in the future. There are lots of programs out there, but unfortunately, those programs are only available to people who can demonstrate that they cannot pay for long-term care out of pocket. So asset protection is definitely something that I recommend people with chronic diseases consider. A lot of people don't feel comfortable with this, though. When I talk about asset protection, sometimes people think, well, maybe I am trying to get over on the government or do something illegal so that I can get some type of assistance. But that's not at all what it's about. It's similar to when you file your taxes every year and you claim every exemption possible because you want to make sure you get all of those credits. This is just a vehicle to allow you to plan, to set aside some assets that may or may not be available to you in the future to supplement your needs, and also being able to get whatever assistance is available through the state. One great misconception that I run into all the time is that people think that because they've paid Medicare taxes and have Medicare coverage, that that is going to cover them if they need any type of long-term care services. And that couldn't be further from the truth. Of course, Medicare is provided to individuals who are 65 and older, and also individuals who have been deemed to be disabled, but they only provide rehabilitation after a person has been hospitalized and need that rehabilitation before they can go back home. But anything beyond 100 days is going to come out of pocket or will need to be paid by some type of long-term care policy. So Medicare, while it is a great option for regular health needs, regular doctor visits, medications, and so on, it is not a long-term care tool. The other program, of course, that I've mentioned throughout this presentation is Medicaid. Medicaid is the only program available for long-term care outside of the VA. So if a person is a veteran, they may have other tools available to them, but if they are not, or a spouse of a veteran, then Medicaid is the only program that could pay for long-term care services. Again, this is a needs-based program that requires people to not only be sick, but be completely broke. So doing planning ahead of time will ensure that you can meet the criteria necessary to get the help. It's not something that can be done on the fly. A lot of people think, well, I don't have the need right now, and when the time comes, I can just do what needs to be done, shift a few things around, and qualify for Medicaid. That couldn't be further from the truth. Obviously, the government is smart to some extent, and want to ensure that people aren't just transferring their assets or giving away their assets just so they can qualify for government assistance. So they do have what's called a 5-year look back period, meaning whenever you apply for Medicaid, they're going to dig into your affairs and figure out whether or not you gave away, transferred, or did anything in the 5 years prior to applying for Medicaid. So this could include giving money to your children. This could include transferring money into an irrevocable trust. This could include just signing over your house to a child because you think that's a good idea. All of those things could be considered uncompensated transfers, which ultimately lead to some type of penalty. In some cases, such a long penalty that it's not even worth pursuing Medicaid further. So for that reason, anyone who has a chronic illness and wants to maximize their options, for lack of a better word, wants to make sure that they have as many different options available to them as possible, it's best to plan as early as possible, preferably well before they need long-term care, ideally 5 years or earlier. If, of course, it doesn't happen, if you don't get to plan early enough to avoid the look back, it doesn't mean that there's nothing that can be done. It just means that your legal advisor has to be more of a strategist, and there are lots of different other tools that have to be implemented in order to reach the end goal. My mouse just disappeared on me. Okay, so now let's look at another example. Let's meet Mary. Mary is approximately 78 years old, recently lost her husband, and her family wanted to make sure she was well taken care of in case her health should fail. She's currently well, but she does have a history of Alzheimer's in her family, and there's a chance that she'll need some type of long-term care in the future. She has children, but they live in different states, and they're worried about her being alone. So let's say that Mary owns a home that's worth approximately $225,000, has a few hundred thousands in checking, savings, and CDs. She does have a long-term care policy that she's had for about 20 years though, so it's only providing about $75 a day in long-term care benefits, which isn't a whole lot. So what exactly would we do as far as long-term care planning is concerned, or proactive planning is concerned for Mary? Number one, we certainly would advise her to keep the long-term care policy, because even if it's not adequate, having it is better than not having it. We definitely would place a portion of her assets into some type of family trust so that her kids could oversee the funds, and also help her as needed. We'd probably keep a smaller portion of her assets in a revocable trust so that she could do home repairs, vacations, anything she wanted. And then we would create supercharged powers of attorneys, health, financial, and living will, to make sure that she's well taken care of and that her children, no matter where they are, could kind of step in and do what needs to be done for her. Now, the result is, if her health should fail, she would have a long-term care policy that would cover a portion of her care costs. Her kids would have access to these trust funds that they could potentially use to bridge the gap between the cost of care and whatever else they want her to have. After 5 years, if we've transferred some money into an irrevocable trust, those assets would no longer be countable for Medicaid purposes. And if she should need some type of long-term care, then her kids would be able to make decisions for her using the supercharged powers of attorneys, and they would have access to those funds on the side to be able to provide for her. Now, if Mary happened to be a veteran or the spouse of a veteran, as I mentioned earlier, the VA does provide a monthly cash benefit to wartime veterans who are 65 or older and require assistance with activities of daily living. It's often referred to as aid in attendance, but its proper name is VA pension with an aid in attendance allowance. It is not the same thing as VA compensation. Compensation, of course, is given to veterans who are disabled or they had some type of active duty related injury, but there's no income or asset limitation to qualify for this type of compensation. But that's not the case at all with aid in attendance. So the laws changed recently, making them actually a little bit easier to decipher, but it still requires that a person has relatively limited resources. So for that reason, even a person who has access to VA benefits would still need to do some type of planning, specifically if they have assets in excess of $100,000. Now, if Mary had done absolutely nothing, the cost of long-term care would likely suck up everything that she has. Her liquid assets would have to be spent down in order for her to qualify for any type of care. If she doesn't have the proper financial powers of attorneys or healthcare powers of attorneys, her children wouldn't just be able to step in, even though they're her next of kin. They wouldn't just be able to step in and make decisions for her. They would have to go through some type of court process to gain guardianship over her in order to make decisions, which costs thousands of dollars. And I don't necessarily want to say this is the most important, but for some it is. There would be no funds potentially left for the children to access to make sure that she has the best care possible. Now, when folks do absolutely nothing, we can still do some type of crisis planning, but crisis planning is not where we want to be. Typically, individuals are already ill, they're in the hospital, they're in a facility, they're paying thousands out of pocket, and they're trying to figure out how to move things around or shift things around so they can get some type of assistance. In those cases, there's still things that can be done. There's still ways to spend down and convert some of those countable assets to be considered non-countable, but our options are far more limited. And in most cases, we're going to end up spending down way more of those assets than we would otherwise have to if we had a plan in place before the crisis arose. So ultimately, the goal here, when we're talking about any type of planning, but specifically when we're talking about planning for individuals with chronic illnesses, is to be able to age with dignity, to have access to the best care possible, to be able to take control over who will manage finances if the person's unable to do so, and to leave a legacy for those that we choose and not those that others may choose for us, or to use those hard-earned assets to leave something behind for our grandchildren and make a difference and not necessarily be forced to spend it all down on long-term care costs. That's essentially it as far as my presentation is concerned. I do want to entertain some questions. Ultimately, planning for individuals with chronic illnesses is not all that different from regular planning, but just having a little bit more strategy behind it, making sure that we're considering all the moving pieces, all the long-term care needs. And if we do that, then we have greater flexibility when the time comes and we need to go into a nursing home or have aid come into our home. So I'm going to stop it there and open it up if anyone wants to ask a question.
Thank you so much, Soraya. So we really appreciate it. Again, if anybody does have questions, please feel free to type those in the chat thread, or you can come off microphone.
Yeah, it can cause some anxiety. Honestly, the biggest tip that I will have for that is to just sit down and start writing it out. What I like to tell people is before you even talk to an attorney or anyone else, just kind of sit down and think about things from a practical perspective. Who are the people in your life that you trust the most? Who are the people in your life that you would never, ever, ever want to ever touch any of your assets? Let's start there. And let's make sure that the people who would not qualify to step in and make decisions for you, that we remove them completely from the plan. And then we break it down from there, figure out who would I want to be the key players? Who would I feel comfortable making healthcare decisions for me? A big thing that I've talked to people about in light of COVID is that I don't know about you guys, but I have seen a big divide between, my friends and family members. And when you think about medical decisions going forward, this is an opportunity to really make you think, are these people's views in line with my own? Would they make decisions that would benefit me, not only benefit me, but decisions that I would feel good about? And we start there, putting the key people in place. And then we figure out, okay, what are my assets? What's my plan? How do I plan to pay for my long-term care needs if they come? Do I have insurance? Do I have 3 years worth of cash to actually be able to pay for things out of pocket? If I do, then I may not necessarily need to worry about locking my assets down into an irrevocable trust. I may want to still maintain access and use it as I see fit. But if I have a limited budget and I know that I want to be able to leave X amount for my children, I want to be able to lock up a certain percentage to leave back for my grandchildren, then you simply decide, this is how much I'm willing to part control with right now. I can set this aside. I know that the key players will be able to access this fund if absolutely necessary. And if I'm completely broke, because they have access to this fund, they will help me, even though I've parted ways with these funds and they're not technically mine anymore. So just having those conversations and being real with yourself about the people in your life and what they're capable of doing. I advise people not to make these decisions from an emotional standpoint. A lot of people talk to me and they're like, well, I have 3 children. I don't want any of them to be left out. I want each of them to feel like they have equal say. Well, that's not necessarily practical. If you have 3 children, you may have one that's not trustworthy or that would completely derail the plan. So just making sure that we understand who these people are, what they're willing to offer or able to offer, and putting them in the right place. I think that's where we start. There's going to be some level of anxiety, though. I'm not going to lie. All right. What can a couple do when one has a chronic illness and one doesn't? Okay, this is a very good question. What can a couple do when one has a chronic illness and one doesn't? How do you make sure that the spouse who is well isn't left penniless if the chronically ill spouse's name isn't on everything? Does that protect the spouse? Not necessarily. The chronically ill spouse's name not being on everything does not necessarily protect the well spouse, but there are provisions for this exact situation. So if we're talking about a couple, Medicaid does allow the well spouse to keep more assets because they understand that you still have to provide for yourself at home. Likewise, if the ill spouse, for example, had the bulk of the monthly income and the well spouse doesn't have enough or doesn't make enough according to the guidelines, then some of the ill spouse's income could also be used to bridge the gap. So really, to make sure that the well spouse isn't left penniless, the assets that are solely in that person's name, they may want to consider putting them in some type of trust or doing something to take them out of their name as an individual so that it could be protected from other creditors. but it doesn't necessarily mean that those funds won't be accessible or available to Medicaid if we're talking about a lot of assets. If we're talking about a modest, I don't want to say a modest family, but if we're talking about a average South Carolina estate, then we're not talking about multi-millions of dollars. We're probably just talking about a few $100,000. And Medicaid does allow the well spouse to retain a portion of those assets for themselves. So they shouldn't necessarily remain penniless, and they will also be allowed to retain their income and maybe even a portion of the ill spouse's income, depending on how much they're earning themselves. But proactive planning is going to be a must in those situations.
Soraya, thank you so much. If there are any other questions, please feel free to put those in the chat or come off mic. I am sharing Soraya's company's website in the chat right now so that everyone has access to that, and you can feel free to look on her website or reach out if you would like further assistance. But with that being said, Soraya, thank you so much for joining us this evening, and we appreciate your time and all the wisdom. And thank you everybody for joining us.
Thank you all for being here, and thank you for facilitating.